with your host, Gene Church. Today's episode, what does it mean to pack the courts and why does it matter? Before we get started on this, I want to say, despite the fact that the Judiciary Committee hearing started today for Amy Coney Barrett, I figure we're going to have plenty of opportunity to talk about that. We've largely gotten to the introduction, which involves Democrats making lots of wild accusations, but for which they have very little evidence to support. And I'm sure over the next few days we'll have a number of opportunities to discuss this. But today, as I pointed out in the tease, talking about packing the court, it doesn't mean carrying a gun. And despite the fact that Democrats are counting on your ignorance, it doesn't mean to empty court seats, to fill up the empty court seats either. Democrats have attempted to intentionally confuse this issue for the American people so that they can push through a destruction of the power of the courts. In an attempt to blackmail the Republicans, Democrats have said that they will pack the Supreme Court if Amy Coney Barrett is confirmed. At first, because the term was not familiar to many people and because the press worked for the Democrats, there was very little on this issue in the press. However, as Biden has been asked numerous times about packing the court, as has Harris, and who has changed her position several times, Joe Biden worsened the position by claiming a few days ago that the public does not have a right to know what his opinion is on court packing, and it became quite clear that the issue was going to be very important in the future. Senators like Delaware's Democrat Senator Chris Coons has claimed that Republicans have been packing the courts, so there's nothing wrong with the Democrats doing it when they take over. Sounds fair, and yet it is a complete lie. President Trump has filled close to 300 federal judiciary seats that were vacant and needed to be filled. This is not court packing. This is the filling of vacancies on the federal bench, something every president does. So what is court packing? The term began to be used in referencing the Judicial Procedures Reform Act of 1937, frequently called the Court Packing Plan. It was a legislative initiative proposed by U.S. President Franklin D. Roosevelt to add more justices to the U.S. Supreme Court in order to obtain favorable rulings regarding New Deal legislation that the court had ruled unconstitutional. The central provision of the bill would have granted the president the power to appoint additional justices to the U.S. Supreme Court, up to a maximum of 6 for every member of the court over the age of 70 and a half years. The Judiciary Act of 1869, in it, Congress established that the Supreme Court would have a Chief Justice and 8 associate justices. But during Roosevelt's first term, the Supreme Court struck down several New Deal measures as being unconstitutional. Roosevelt wanted to reverse this by changing the makeup of the court to the appointment of new additional justices who he planned to have rule that his legislative initiatives did not exceed constitutional authority of government. Sadly, this technique has been used by a number of third world dictators to make the courts a reflection of those in power and to rubber stamp their actions. Since the U.S. Constitution does not define the Supreme Court size, Roosevelt claimed that it was within the power of Congress to change it. Despite the fact that Democrats control both houses of Congress, the House of Representatives and the Senate, members of both parties viewed the legislation as an attempt to stack the court, and many members, interestingly enough, including Vice President John Nance Gardner, opposed it. The bill became known as Roosevelt's court packing plan, a phrase that was coined at that time. 84 years ago, in November of 1936, Roosevelt won a sweeping re-election victory. In the months following, he proposed his plan to reorganize the federal judiciary. The legislation was unveiled in February of 1937 and was even subject to his 9th fireside chat in March of that year. He asked, quote, "Can it be said that full justice is achieved when a court is forced by its sheer necessity of its business to decline without even an explanation to hear 87% of the cases presented by private litigants?" Publicly denying the president's statement, Chief Justice Charles Evans Hughes reported, quote, "There is no congestion of cases on our calendar. When we rose March 15th, we had heard arguments in cases which cert had been granted only 4 weeks before. This gratifying situation has been obtained for several years," end quote. Cert, by the way, is a writ of certiorari, a decision by the court that there is a significant enough issue to raise it before the Supreme Court. So not all cases make it to the Supreme Court. While the court ruled in Roosevelt's decision shortly thereafter, and it claimed that FDR's pressure got a member of the court to change sides on an important case, there really is no evidence to support this claim. Roosevelt's legislative initiative had ultimately failed in this regard. The bill was held up in committee, didn't come out for almost 6 months. Congressional and public opposition ended the bill, and it died. However, the attempt itself politicized the public's view of the court, and it hurt the credibility of the Supreme Court over the next 10 years. So when the term court packing is used, it references trying to increase the number of justices on the Supreme Court so that the existing president can fill a number of new vacancies. Article 3 of the Constitution establishes a federal judiciary. Article 3, Section 1 states, quote, "The judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish," end quote. Although the Constitution establishes a Supreme Court, it permits Congress to decide how to organize it. Congress first exercised that power in the Judiciary Act of 1789, creating a Supreme Court with 6 justices. It also established lower federal court systems. Over the years, various acts of Congress have altered the numbers of seats of the Supreme Court from a low of 5 to a high of 10. But since really shortly after the Civil War, the number of seats have stayed at 9. Today we have 1 Chief Justice and we have 8 associates in the U.S. Supreme Court. Like all federal judges, justices are appointed by the President and are confirmed by the Senate. They typically hold office for life, and their salaries cannot be decreased in term. These restrictions were intended to make sure that they were independent from the political branches of government. The best known power of the Supreme Court is judicial review, the ability of the court to declare a legislative or executive act in violation of the Constitution, and it is not found within the Constitution itself. The court established the doctrine in the case of Marbury versus Madison in 1803. Court decisions have been determined that the court has power to determine the constitutionality of federal and of state actions. I apologize there. So why is this so upsetting? There are several things that prominent Democrats have proposed doing should they take over. For example, one of them is declaring Washington, D.C. a state. Article 1, Section 8, Clause 17 of the Constitution states that Congress shall have the power to exercise exclusive legislation on all cases whatsoever over such district not exceeding 10 square miles as may by cession of particular states and the acceptance of Congress become the seat of government of the United States. Many constitutional scholars contend that this prohibits the district from being within or controlled by a state. But if Democrats want it to be a state along with Puerto Rico, which has lacked public support for statehood, they have decided to do so. Why? Because with 2 more states would be 4 more senators and a weakening of Republicans' influence in the Senate and a redistribution of the Electoral College votes. A packed court could declare that the Second Amendment does not give individuals the right to have guns. It could declare that religious institutions are required to allow LGBTQ weddings within their churches, or that public scripture readings constitute hate crimes and are not protected by the First Amendment. They could do literally whatever they wanted, since liberals do not believe that they're bound by the intent of the legislature and have authority to legislate from the court. Also, Joe Biden doesn't want to make the same mistake that FDR did and state his intentions on this matter. Why? If he stands opposed to court packing, he will irritate his liberal supporters who want it. If he stands in favor, he risks angering voters and perhaps not get the chance to pack the court. The major purpose of this is to create one-party government and to keep it that way. The concept of balance of power will be further eroded, and the powers of the court will be established not by a balance of power, but by the control of a one-party state. So when you hear Biden refuse to tell you his position on this, or say to you that you have no right to know, remember, he has no right for your vote either. Don't give it to him. What are the three things? Find Gene Church.